Welcome, everyone. Thank you so much for joining us today on our, I was going to say webinar, but our panel regarding cybersecurity developments in the legal landscape. If you could just take a moment to look at the disclaimer, some housekeeping that we're required to present to you. And I've never done the clicker, so I'm going to say, please bear with me. Oh, how did I do the next one? Yeah. Oh, I'm so sorry. I guess you didn't see the disclaimer. There we go. You see it? Okay. Get that housekeeping out of the way. Okay, the agenda. So today we're going to be talking about the latest developments in cybersecurity, ransomware, and also federal, regulatory, and state-level developments. We will also be discussing, Ben's going to be talking about OFAC and FinCEN, their developments and recommendations that they have. We will be touching upon examinations, investigations, and enforcement actions around cybersecurity practices and ransomware, and at the end, suggested best practices. It's a lot of information, and we will be looking at our notes because we want to make sure we cover as much to give you this information, and also there's a lot of different time periods in terms of complying. And for those of you that are dealing with this in your company's head of cybersecurity, CISOs, we feel for you. There's a lot out there and a lot of different requirements, and we're here to help you guide through that. I'm going to turn over the next few slides to James.
Hi, good afternoon, everyone. So, what we're hoping to come away from this is, number one, that there's a lot of regulations that are being promulgated across different regulated entities, different sectors, as well as the broader community in the United States, and these are going to impose additional requirements from the legal and regulatory standpoints on cybersecurity programs, your reporting obligations, and different layers of compliance, including technical compliance. And so this is what we've seen as we've practiced and we've advised companies over the last few years, is that we've seen an explosion in sort of state and federal sort of privacy standards, and particularly state cybersecurity standards that are starting to have more of a technical focus to them, right? So it used to be, particularly in the financial services space, you would have, a generic regulation that said you will maintain a, information security program, and you'll respond to incidents, and that'll be it, right? And now, over the course of the last 3 to 4 years, there has been standards that have been imposed now, because a lot of regulators are saying, well, it's not enough that we tell, our regulated entities that they just need to have a program, right? We need to tell them they need to have multi-factor authentication. They need to be able to do change management properly. And so, for people who are mostly focused on sort of a NIST cybersecurity framework or something like that, it's also very important, as part of a lot of these developments, is to monitor the regulations, because a lot of these regulations are going to impose either additional standards or standards that are maybe inconsistent with what the organization thinks is appropriately risked and all that stuff. So we're starting to see that in multiple fields, particularly in the financial services space in which we operate. But we also see emerging regulations in energy space, in the health space, and we'll get a little bit more into those particular requirements. Clicker. So. And also, we also have regulatory agencies not only promulgating regulations, but also guidance that they basically expect the regulated entities to follow. So this is a little bit harder to track sometimes, because you have to keep up with the regulators, and a lot of the in the advent of Russia, Ukraine, and ransomware attacks, there have been basically updates. We know most of you are tracking the CISA updates, with ransomware, and the NIST updates, but the regulators are also issuing their own guidance on what they expect in particular fields, and what we see sometimes is, as we advise companies, is they're not tracking those additional guidelines that regulators will want you to follow, and during an examination, which we'll go through later, that could come up as a problem. And finally, the reason why we care is because penalties are going up. For very small infractions, what used to be probably small infractions, we're seeing, millions of dollars of civil penalties. And part of what we're trying to show here is, as part of ransomware is starting to create a wider scope of headline incidents. We used to look at DDoS and data breaches and such. But ransomware has so many different types of extortion schemes, and the liability that we've seen, the legal liabilities and the theories behind lawsuits that occur as a result of these are starting to become more and more interesting, right? It used to be you get sued because somebody said you lost your data, right? But now it's, you might have caused the death of a patient because, your medical record wasn't there when the ransomware hit and they couldn't do the operation. This is sort of something that's going on right now, right? So I think, as you guys understand the progression of ransomware and the double extortion and multi-extortion, the legal theories of liability that are incurred in organizations that experience these events are starting to become more and more complex. And so it's something to really think about as you're looking at your risks and also as you're looking at your response. So there's a few common ransomware myths. Most of you have probably seen these, but it makes sense to go over these because we've advised clients on this. But, a lot of times, like, we'll have clients that tell us, hey, we didn't lose any data, we're good, right? So there's nothing to report, right? And the regulations are now moving to a point where they want to see, if you've experienced a substantial event, they want to know about it. It's not just about the loss of PII, right? It's about disruptions to your information systems or your business operations. So the scope of reporting is expanding. A ransomware attack failed, so it's not a reportable event. That's the same. A lot of states are starting to pass laws that are talking about reporting these events, even if they're not successful, right? And as Ben will discuss a lot further down, making payments. If it comes to pass that a payment needs to be made, there's a lot of considerations that we're going to share with you today on sanctions and sort of violations of OFAC regulations for making payments and those who assist in making payments. And then, we've seen a lot of cyber insurance companies sort of exit this area because of the risk, but for the remaining insurance companies that remain, premiums are going up, coverage is going down. So it's important to sort of make sure, and we'll cover that later. And finally, I don't really need to go through the last bullet because we all know this, right? So, okay.
Okay, so I'll be talking about the federal regulatory developments, and we're seeing a lot of common themes with the different agencies. The themes are notification and reporting, implementing technical requirements, and we're seeing that more and more. The classifying material events, cyber events as material events, and I'm going to be using this word quite a bit. Conducting pen testing, vulnerability assessments, board involvement in cybersecurity programs, and that's really being looked at by the different regulators and the different types of expertise that they want from board members. And then also a single responsible senior officer to implement the cybersecurity program. So just a few months ago, President Biden signed the Cybersecurity Infrastructure Reporting Act, and the act requires within 72 hours from when a company reasonably believes an incident occurs and 24 hours when a ransom payment is made. The act requires CISA to do a mandatory rulemaking process, and in September there was a request for information issued because they do want comments on this law. There's two ways that this will go about: putting in comments for the request of information or listening to what CISA says. They're having these open meetings around the country. It's interesting, the request for information, what they're asking people to opine on, definitions, reporting requirements, how they're to report, how this will be impacting companies in terms of timing and expense. This is something that will be interesting to see how the comments come through and what will be taken into consideration. There is, as the slide said, optional reporting until this rule becomes final. CISA would like to see that if a company that's in the critical infrastructure sector has an incident, that type of voluntary reporting. Do you mind doing that? So we also saw last year the FTC amending the cybersecurity rule. A lot of the requirements came into play in January, the remaining December 9th. Two things I think when you're looking at the amendments is how they broaden the definition of financial institutions. So if you are working in that space, it's important to see if you fall under that. They also had a carve out for small businesses. They made the information security provisions very similar to DFS's and what they are requiring. So it's important to look at those. A lot of them are being required to go into effect in December. The other issue around this that's important to note is the accountability. They want a qualified individual to be in charge of the program, and that qualified individual needs to report to the board on an annual basis on how they're complying with the safeguards rule and if there's any material impact that they've experienced. So those are, what the FTC, and they wanted to keep up with technology because the rule went into effect in 2003. So it was about time to brush off a few things. And again, it mirrors almost exactly, we could say, DFS. The federal banking agencies issued a rule in terms of notification, and that went into effect May 1st, and that was the OCC, Fed, and the FDIC. And they would they require incidences to be reported as soon as possible and no later than 36 hours after determining an incident has occurred. They also require service providers to banking organizations to also report as soon as possible. One thing, they give examples of what they consider incidences. They didn't give, in terms of how you report the incidences, they weren't they were very general in terms of the notice and how to do that. And one of the reasons was they realized the timing was quite short and they wanted companies to be able to notify rather than being bogged down with the type of notification. It's important to note here that this isn't a breach notification a rule. It's notice about security event that causes significant disruption or impacts a banking organization's ability to do business or materially harms the company. And that's what they wanted to do. They want to, in their comments, they say they're not trying to put more burdens on the financial industry, but they want to protect and help and give others a notice of what's going on. So therefore, you may need to report an incident to other regulators or to states. So unfortunately, it's more requirements on you, but the federal banking regulators were trying to make it easier in terms of notice. Just touching upon the National Credit Union Administration also recently proposed their comment for reporting, and that's 72 hours after reasonable belief that an incident has happened. The comment period ended in September, so it'll be interesting to see what comments they received and if that's going to change. HHS has always issued guidance in terms of reporting, and they have also issued guidance on how to respond to ransomware attacks. Last is the SEC. They did a proposed rule in March. Their comment period was ended in May, but they had trouble getting comments from people, technical issues, which is a little bit ironic given what they're putting on companies, so they've extended that. There are three things that I'd like to mention about the proposed rule. One is requiring public companies to report material cybersecurity incidents within 4 days after determining that an event has occurred. The second is reporting to the SEC any previous incidences that you may have had, if they've developed, had a material impact, if there's been any changes to those. So, prior to whenever the rule's final, if you've had something and it's changed, they want to know. And then lastly, which has had a lot of criticism by people, is the reporting of the company's cybersecurity risk management policies and procedures. And there's a lot of information that they're asking. So it's good to read the rule on what they expect companies to report in their annual reporting. And the concern that a lot of people have had about this is that if they are to disclose, and if this hasn't changed, cyber criminals, it's almost like a playbook for them to see what companies are doing, because some of the things they ask for are the business continuity and recovery procedures, how cyber risk might impact the company's financials, how they engage with third parties, the outline description of their cybersecurity risk program. So it'll be really interesting to see what happens with this comment period. They did give examples on what to put in terms of the reporting. They give examples of the types of reports. So again, something that you should be on the lookout, and we are as well. Next page, please. Before I go into these, the guidance, I want to mention that DFS is amending their cybersecurity regulation. They just celebrated 5 years, and they had a panel and celebrating, but they did do a lot of FAQs when this regulation was issued, and they want to keep up with the times, and they feel like with the questions they got in terms of compliance, some difficulty, but also how technology is changing, they believe it's time to do that. And some of the areas that in the amendments that we've seen is new requirements around CISOs, what they need to do and what is going to be required of them. New guidance requirements in terms of board involvement and their expertise. They want someone with expertise on the board, and that's going to be interesting how they define that expertise. Annual risk assessments, treatment of privileged accounts, new disaster recovery, and new requirements for ransomware attacks. I think the amendments are very similar. We're seeing similarities between that, the SEC, and the FTC. So that is just basically a way of looking at how all these they're coming together. I think that, the DFS was the first, FTC, as I mentioned, came along, and now the SEC. Unfortunately, I think we could see maybe others that will follow, and states as well. So as I mentioned earlier, we have sympathy with trying to track all this because it's not an easy thing to do. DFS, talking about insurance, they realize, James had mentioned something about the cost of insurance. They issued the first cyber insurance risk framework because they want to make sure the insurance companies themselves are evaluating their risks and determining what they need to do. DFS has the multi-factor authentication guidance. It's always been important, and it's one of the few technical requirements in the cybersecurity reg. What they've seen, and we've seen them asking this, and I'll mention this later, in examinations and enforcement actions, they're seeing companies not using multi-factor, or it not being implemented, or making exceptions. The DFS has mentioned how some senior people at companies don't want to do multi-factor, so IT kind of gives them the pass, and that's been problematic. DFS issued ransomware guidance, I guess you could do the next page, James. And those are, rather than listing all of them, those are the ones that they require and that they think financial institutions, entities covered by DFS, it'd be helpful for them to implement this to guard off and do the best they can. The ones that I think, what we're seeing a lot of I guess in enforcement actions, deal with multi-factor authentication, not doing risk assessments, training employees. A lot of these attacks are coming from, employees that they're not aware of a phishing attack, and, or not doing, tabletop exercises, having too many documents and not having a document retention program. And privilege access management. So all of these are important, but just touching upon some of the ones that we've seen in some enforcement actions is something to be just aware of. So over to you guys.
No, so that was great. And so one of the things, like, we focus on New York DFS because we had, to Beth's point, they've kind of led the way on the sort of technical cybersecurity regulation in the financial services space, which, it was always a question of whether it would expand to federal regulations or not. And we're starting to see that this year. The FTC took notice. Now you see the SEC doing the same thing. So I think a lot of the federal developments on the regulated space, they're taking cues from some of these state models, and they're starting to implement these requirements. And what you see is sometimes they may not align perfectly to like a NIST concept, right? And so, if you're basing your program on some sort of industry standard, ISO, NIST, right? And you have to take a look at these requirements because they do present technical requirements that may not be perfect for your organization, but they are requirements nonetheless that you at least have to work through. There's some additional guidance for anyone that's working in sort of the virtual currency space. New York DFS from a financial perspective has taken notice that most ransomware payments are done through virtual currency. They are, and then as well as the expanded sanctions, right? Ben, you could probably talk more about the sanctions in a second, but the idea here is that they want companies that are in crypto to do blockchain monitoring, right? They want you to review the blockchain, review transactions on the blockchain for evidence of payments, to sanctioned entities and things like that. So why don't you talk a little bit more about that part?
Yeah, sure. So I think as a general background, I think we're all probably all aware of events with Russia and Ukraine, but in response, Treasury's our sanctions arm, which is OFAC, which I'll explain a little more in a minute, essentially imposed all sorts of sanctions on Russia and on a lot of Russian companies. And so New York and the federal regulators essentially said, well, beware, we expect retaliation, and we expect, essentially Russian cyber or ransomware groups, right, to try and infiltrate and try and strike back, right? So that's for the people that aren't even financial institutions, but everybody, right, be aware of that. But then second, the other piece of this is that we expect Russia to be evading our financial sanctions using virtual currency transactions, but we also expect Russia to be getting ransomware payments, or not Russia, but Russian ransomware groups to be getting payments in virtual currency, right? And it said, well, financial institutions be aware of this, right? So the takeaway for people from financial institutions that are in this room are, well, be aware of it and report it and do what you're supposed to do. But the people who aren't financial institutions, this is a theme that's going to come up, I think, is that, to the extent you're thinking of paying a ransomware payment, there's going to be, your financial institution is going to be looking for that type of activity, and they are in all likelihood going to try and report it to the government if they detect it, right? So that's just another layer of consideration on trying to think about how you respond to some of these ransomware incidents.
So just a couple other things to be aware of. There are some states that are passing laws on ransomware specifically. These are over and above what you might know as traditional state data breach laws. If you have experienced a data breach, you have to report in every state and sometimes to the attorney generals. They're starting to pass some laws related to ransomware. Right now, most of the laws are limited to state and local agencies, but to the extent you're working for a state or local agency, they're starting to prohibit payments. Ransomware payments. For Florida and North Carolina specifically, if you're a state agency, it is prohibited for you to make a payment. There's some states that are talking about prohibiting possession and or use of ransomware code. I think right now it's possession and intent to use. So, for incident response firms and analysis firms, that's a big concern there if they take the intent to use out. But the idea there is that there's a lot of movement among the states to try to regulate ransomware payments and ransomware activities, and to also get the same thing. So this is being layered, right? You have CISA that wants to be notified. You have your regulator, if you have one that wants to be notified. You're going to have states that want to be notified. So your notification obligations are going to get increasingly complex when you experience an incident.
Great, thanks. So we thought it worthwhile talking about the regulatory overlay of money laundering economic sanctions as it applies to ransomware. I thought it'd be worth just for a minute doing a little bit of a 101, because I'm not sure a lot of people in this room sort of deal with those issues on a day-to-day basis, right? So I think the overall point is that in addition to the sort of legal reporting and technical obligations James and Beth have been talking to you about, there are some real and significant legal risks associated with ransomware payments that arise under federal money laundering and economic sanctions laws. These apply both with respect to victims thinking of making a ransomware payment. They apply both with respect to the digital forensic incident response companies and cyber insurance companies that make ransomware payments on behalf of third parties. And they apply to the banks, the money transmitters, and the virtual currency exchanges that are processing those payments, right? So who has an interest in regulating ransomware payments? Well, first, the Office of Foreign Assets Control That's the arm of the Treasury that administers U.S. sanctions laws. You know, U.S. sanctions is a very broad matter, are essentially economic warfare against countries, individuals, entities, groups that are a threat to national security or our interest. It is relatively, if it's not clear from the first 10 slides, I'll just say it, right? Ransomware is a very high national security interest, and cybersecurity is a very high national security interest. That's not news to any of you, right? So what it means is OFAC gets involved, particularly in targeting, for example, foreign ransomware groups, foreign virtual currency exchanges that ransomware groups use to receive payment, and people making payments to sanctions targets, right?
Down to the Bitcoin wallet of detail, right? So there's
Yes.
specific wallets that get listed
Yeah.
as sanctioned entities. So.
Yeah, exactly. There's specific like virtual currency wallet. That's right. So what are OFAC's prohibitions when they target somebody, when they target a ransomware group, when they target a ransomware payment facilitator? The essential prohibition is U.S. persons can't transact with them, right? So if there's a sanctions targeted ransomware group, you can't pay them because that violates sanctions, which are strict liability, which means that even if you don't know the identity of the ransomware group, if they turn out to be a sanctions target, you still violated, right? So that's an additional layer of risk. The second regulator that cares about ransomware payments to a significant extent is the Financial Crimes Enforcement Network, also a part of the Department of Treasury. Their job is to safeguard the financial system from being used to, process and illicit use, and they combat money laundering. How does money laundering relate to cybersecurity and relate to ransomware payments? Well, in two ways, really. The money laundering laws essentially say that money made from a whole litany of types of crimes can be subject to forfeiture by the US government in order to de-incentivize people getting money from crimes, and also transacting in the proceeds of those crimes is money laundering, and doing so with intent to sort of, hide the proceeds of crime is a crime itself, right? So ransomware is one of those underlying crimes that generate sort of money laundering. FinCEN essentially regulates, quote, financial institutions and requires them to do things like maintain programs to prevent money laundering. Essentially, the core of that is to detect potential money laundering, detect potential illicit payments that are flowing through them, and report that to the government, is really sort of the core requirement. And from those reports, FinCEN collects information about potential financial crime and sends that to the government. Next slide, please. So how does that relate to us here? Well, there's some significant risk concerns under the sanctions laws and money laundering laws when you think about paying or processing a ransom either for yourself or for a third party, right? For OFAC, right, if the ransom has a nexus to a sanctioned person or a jurisdiction, right, you can't pay. Right, so for example, OFAC has targeted multiple ransomware groups, so you can't pay them, right? Well, what happens when a ransomware group gets targeted by OFAC? I mean, they probably don't identify as the same group anymore because nobody would pay them, right? Or what happens, an interesting thing I saw about a year ago, there was a ransomware group called, was it DarkSide?
DarkSide, yeah.
DarkSide that said we're gonna move our operations to Iran where they're not gonna be regulated, and they had to walk that back because nobody would pay them because you can't make payments to Iran. Right, so if you are targeted by a ransomware group, right, you need to know who's on the other end to know if you're going to be compliant with OFAC when making the payment. If you're making a payment for someone that's a ransomware payment, you need to know the same thing. What is the risk under FinCEN? The risk under FinCEN is that really with respect to third parties making payments on behalf of others. So for the digital forensics groups that have like their own store of virtual currency to make payments out of, or for the cyber insurance companies that make payments on behalf of third parties. Well, if you do that, you can be considered a money transmitter under FinCEN's regulations, which means you have to register as such, you have to maintain an anti-money laundering program, and there can be significant penalties for not doing so, right? So if you're operating in that space, you really need to think about whether you should be making payments on behalf of third parties, and if you are, right, well, what the legal implications of that are. Next slide, please. FinCEN and OFAC have issued, I want to say 4 or 5 advisories on ransomware in the last year or two, right? They don't issue a lot of advisories, so you can just from that and figure out what the priorities are. So what happens if a ransomware group is a sanctions target and they don't care and they're saying, well, pay us anyway? You can apply to OFAC to say, can I please pay these people so I can have my data back and operate? OFAC's general answer is going to be no. Their guidance strongly discourages ransomware payments. And so the other thing to recognize is if you facilitate ransomware payments for people to a sanctions target, you can also violate OFAC, and the penalties can be quite steep. So again, this is just another, I think, cautionary tale on if you're a financial institution yourself, whether you should be processing a ransomware payment, right? If you are, you should definitely be reporting it to FinCEN, or if you're paying a ransomware payment, you can be rest assured that if your bank or other financial institution detects that it's ransomware, they're going to be reporting that to FinCEN, who will be in turn reporting it to law enforcement. Next slide.
It's not guaranteed that you'll get your data back either. So you could be without data, huge fine as well. So
Exactly. It's your bad spot, I guess. Next slide. Right, I think I mentioned this before, but OFAC penalties are based on strict liability, meaning that even if you don't know who's on the other end of a payment, if OFAC figures out that they're in, for example, Iran, figures out they're a sanctions target, you violated, you could be liable. Interestingly, OFAC has a set of enforcement factors that it thinks about when essentially deciding on how hard to penalize or how badly to penalize somebody. And that normally has things to do with how good is their sanctions compliance program, how good is their software they're used to detect the names of like sanctions target in their transactions. But they have this specific thing with respect to ransomware payments that if you have a good cybersecurity program, right, they will not come down on you as hard as if you don't, right? Which is just another regulator getting into the mix, right? And not only does it just send, do you have a good cybersecurity program, but as you can see on the slide, right, there's all these different things that OFAC thinks is a good cybersecurity program, which don't necessarily align with what New York thinks is a good cybersecurity program, which don't necessarily align with NIST, right? So I think the big one on here is the self-initiated complete report of ransomware attack to law enforcement. There's significant emphasis on reporting it to law enforcement, so if you're worried about having to pay to a sanctions targeted group, I think you probably want to get law enforcement and OFAC involved sooner rather than later, because that will mean you come out better. Next slide, please.
And correct me if I'm wrong, this is like one of the first times OFAC has really talked about cybersecurity programs as sort of a mitigating factor to any sort of violation.
Yeah, that's right. Yeah, OFAC usually talks about how good are you at not transacting with who you're not supposed to transact with, right? That's what they care about. So this is actually to come up with a set of mitigating factors in cybersecurity. I think will show you the priority they're putting on this. FinCEN had a similar type of advisory and prioritization. So FinCEN actually has to list the financial crime priorities that it wants to fight, right? So for example, human trafficking is up there, narcotics trafficking is up there, or at least money laundering related
corruption
to those.
being up there.
Yeah, preventing money laundering of proceeds of corruption is up there. Ransomware is also up there, listed as a particularly acute concern. FinCEN encourages financial institutions to share information among themselves about potential ransomware payments. So if your bank is banking you and another bank is banking your digital forensic incident response firm, right, and there's a payment in between, right, they can talk to each other and figure out what the heck that's for. What does that mean? It means the likelihood of you getting reported to FinCEN is even greater, right? And then the other thing is FinCEN has said if a bank or other financial institution detects a ransomware payment, right, they usually have something like 90 days to file what's called a suspicious activity report. In this case, they're required to immediately call law enforcement and inform them, right? So again, just more reporting. And again, similar to the New York Department of Financial Services guidance, there is some additional risk baked in with respect to Russian sanctions evasion, increased Russian ransomware attacks, and the related use of crypto for payments. Next slide, please. And so FinCEN and its advisory also listed red flags of potential ransomware payments that financial institutions are going to bake into their monitoring software to help them identify potential ransomware payments and again report them to law enforcement. I should note FinCEN, like OFAC, has strongly discouraged making ransomware payments and strongly encourages law enforcement reporting related to ransomware attacks. The one I think people that are in the digital forensic incident response or cyber insurance field should look at as number 5, right? Which just shows you again that financial institutions are sort of looking to see if you're making payments and reporting them to FinCEN, and then FinCEN is going to consider whether you are unlicensed money transmitter.
Yeah.
All right, and I think, well, we probably don't need to give the rest of them. Next slide.
I mean, I think what you'll see with the red flags is, for those of you who've worked on ransomware incidents, probably many in this room, like you'll see it kind of covers the end-to-end of how they take the virtual currency, mix it, do all that stuff. They're looking for all those kinds of transactions as well along the blockchain too.
So we're seeing cybersecurity to be a focus in exams, investigations, and enforcement. I mentioned that earlier. DFS in their exams they're asking more technical questions. I feel like a bit of a broken record with some of the things that I've mentioned before, what the practices they expect you all to do, but this is what they're asking for: multi-factor authentication, access controls, training. Is the board involved, the CISO, their expertise? They're asking for documents, they're asking for resumes. Document retention in terms of, they don't want companies to keep more than they need to because of the risk. So those are the areas in terms of examinations. The SEC is similar, and they issued a report a few years ago that's interesting for companies to read. It was part of their National Exam Program Risk Alert, and what they did, they did like a study of all these companies that had their exams, and then commonalities of what they found, and it was everything from not having a good cybersecurity program, from not following their policies and procedures, not training, working on old systems and not, taking systems off. So that's something that, the regulators, there's some that do release some information, and it's a good guide. In terms of enforcement, I know James is going to mention a case, but are you going to mention the one today? Or?
I know, why don't you go?
Okay.
So, today, go ahead.
Hot off the press, the DFS settled with a vision care company for $4.5 million, and that is a higher fine that we're seeing. Typically, their enforcement cases have been around after a breach, and that doesn't mean that something could not come out of an exam. But in this case, there was a breach for this company July 1st of 2020, and it was a phishing attempt, or the successful one, and where on a mailbox that had 6 years worth of PII information, they had 9 individuals sharing the same password and the same account. So they were, and no multi-factor authentication throughout. So they were basically, hit with no multi-factor access privileges because multiple people had the same mailbox and the passwords, data retention, and also risk assessments. If they had been doing risk assessments, they might have been able to catch these things. So, and also certification. As many of you all are aware, at the end of the year, you need to certify you're compliant. If you're not, you don't certify. They don't want false certifications. And this company did it from 2018 to 2021. It's interesting to see the amended, what they're saying about DFS. That certification may be changing, which could be helpful for companies. So that's another reason why we're very curious as to see when that comes up. I think things will be a bit better. James.
Yeah, so I mean, we've been tracking York DFS civil penalties and enforcement actions because they're actually sort of leading the way on cybersecurity enforcement. And traditionally, we wouldn't see, for headline breaches, obviously you would see a lot of penalties brought by attorney generals and the FTC. But what we're seeing now is probably comparatively smaller violations, small data breaches, small breaches of compliance programs, generating, millions of dollars of civil penalties, right? So this is sort of important, as you kind of look through, programs and the exposure. And we've seen this like up to, I think, $30 million, for one company, the headline company, for their violations. And it's a large investment company, it takes a lot of retail investors and things like that. So it's important to know that the penalties are going to be pretty steep, if an incident occurs, at least for now. But if an incident occurs and they start to peel back and look under the hood and say you're missing all these things, right? That's when a lot of these penalties kind of come in. Okay.
Yeah, no, the FTC has had a bunch of different workshops around cybersecurity, ransomware, and it's always good to look on their website. They do have guidance in terms of, ransomware best practices for companies in terms of safeguarding customer information, and also what they would like to see corporate boards do. There have been recent enforcement actions around data security. What the takeaways from like 3 recent cases, without naming the companies, they did not have a comprehensive information security plan. They did not follow their privacy policies on how they protect customer information. And that's something, if you're going to say it, you better do it. The FTC is very much on that. And also supervising third parties. A lot of the problems they had was as a result of third parties' breaches with third parties, and then the companies not checking, doing their due diligence, baking into the contract that, how are they safeguarding things, doing risk assessments, not only of the third party, but also the software they use. So those were the takeaways. Dark patterns, we could do a whole conference on that. That's a hot topic. There has been an FTC case, and was it today or yesterday? There was the CFPB sued a company as a result of junk fees and dark patterns in terms of company, people that were registering for races. It was an online and other events. They were automatically put into some type of advantage program without knowing. So dark patterns is, as regulars say, trickery. You don't know what you're clicking on. You can't, unsubscribe. So the FTC, we're going to see a lot around them. They've had workshops. They're issuing guidance. So that's another something to unfortunately keep on your radar.
Okay, we're running out of time, but we're going to run through the recommendations real quick, but hopefully incorporating everything that we've talked about.
So for FinCEN, who regulates financial institutions for anti-money laundering compliance, right? They say incorporate indicators of compromise into company security systems so that they themselves know if they get hacked, right? You guys are well aware of that for everybody. Again, contact law enforcement immediately regarding ransomware activity, or if there is any reason to believe there is a sanction connection, right? Meaning that if you're not a financial institution making a ransomware payment, again, your bank is looking to report on you. And then again, report suspicious activity to FinCEN with cyber indicators, which essentially allows law enforcement to plumb FinCEN's database for cyber and ransomware related events. So it allows law enforcement to become aware that you made a payment, which I think argues towards getting law enforcement involved in sooner than later. Next slide.
I think it goes without saying, everybody knows to build a ransomware playbook. The reason why we wanted to highlight the ransomware playbook is there's a number of topics that you can see that will enable you to kind of bring in the right parties, right? I think one thing that's emerging from the cybersecurity regulations that we see is that you're going to have more coordination between the General Counsel's office, the compliance department, to the extent you have any sort of sanctions team, and then privacy and cyber. They all kind of have to come together. And one place they do come together is the ransomware playbook. Is if you have to put a payment policy together and all this stuff, it's good to have the right players in the room.
Cyber insurance review is so important. Besides reviewing your policy, checking in with your insurance, who you report incidences to and how, make sure you're aware of the exclusions. We're seeing more and more different types of exclusions, everything from unencrypted data, where the incident happened. You have employees working overseas or going overseas on vacation and something was stolen, paper records, exclusions for acts or omissions to your employees if they've made a mistake. And also think about if you work a lot with third parties, some companies are getting insurance for third parties in case there's a breach on their end. Again, I mentioned that we're seeing a lot of breaches, unfortunately, from service providers. So that's something to think about. But I think when you look at the insurance, really the exclusions right now are really important because they are changing.
And last but not least, risk assessments are, I think one thing you need to think about for risk assessment is the regulatory and legal implications, stemming from these things, right? The costs of regulatory fines are increasing, examinations, things like that.
Paying lawyers.
Paying, and I think, what's important is to go back to your risk assessment, really understand what happens, like if you fail to meet these regulatory requirements, and I think it'll help you in terms of, investment strategies and cost trade-offs, and I think it's really important to kind of at least take a quick look based on the evolving landscape and figure that out.
It helps with budget planning too.
Yeah, too, exactly, investment planning and all that, so. That's just us and our contacts. Sorry we went over a little bit today, but hopefully you found this helpful.